The Agreement on Trade-Related Investment Measures are rules that apply to the domestic regulations a country applies to foreign investors, often as part of an industrial policy. The agreement was agreed upon by all members of the World Trade Organization. The agreement was concluded in 1994 and came into force in 1995. The WTO was not established at that time, it was its predecessor. The GATT policies such as local content requirements and trade balancing rules that have traditionally been used to both promote the interests of domestic industries and combat restrictive business practices are now banned. Trade-related investment measures is the name of one of the four principal legal agreements of the WTO trade treaty. TRIMs are rules that restrict preference of domestic firms and thereby enable international firms to operate more easily within foreign markets. How it came in action. In the late 1980s, there was a significant increase in foreign direct investment throughout the world. However, some of the countries receiving foreign investment imposed numerous restrictions on that investment designed to protect and foster domestic industries, and to prevent the outflow of foreign exchange reserves. Examples of these restrictions include local content requirements, manufacturing requirements, trade balancing requirements, domestic sales requirements, technology transfer requirements, export performance requirements, local equity restrictions, foreign exchange restrictions, remittance restrictions, licensing requirements, and employment restrictions. These measures can also be used in connection with fiscal incentives as opposed to requirement. Some of these investment measures distort trade in violation of GATT Articles 3 and She, and are therefore prohibited until the completion of the Uruguay round negotiations, which produced a well-rounded agreement on trade-related investment measures. The few international agreements providing disciplines for measures restricting foreign investment provided only limited guidance in terms of content and country coverage. The OECD Code on Liberalization of Capital Movements, for example, requires members to liberalize restrictions on direct investment in a range of areas. The OECD Code's efficacy, however, is limited by the numerous reservations made by each of the members. In addition, there are other international treaties, bilateral and multilateral, under which signatories extend most favored nation treatment to direct investment. Only a few such treaties, however, provide national treatment for direct investment. The Asia-Pacific Economic Cooperation Investment Principles adopted in November 1994 are general rules for investment, but they are non-binding legal framework. GATT 1947 prohibited investment measures that violated the principles of national treatment and the general elimination of quantitative restrictions, but the extent of the prohibitions was never clear. In addition, it provides an illustrative list that explicitly prohibits local content requirements, trade balancing requirements, foreign exchange restrictions and export restrictions that would violate Article 3, 4 or She, 1 of GATT 1994. TRIMs prohibited by the agreement include those that are mandatory or enforceable under domestic law or administrative rulings, or those with which compliance is necessary to obtain an advantage. Figure 8-1 contains a list of measures specifically prohibited by the TRIMs agreement. Note that this figure is not exhaustive, but simply illustrates TRIMs that are prohibited by the TRIMs agreement. The figure, therefore, calls particular attention to several common types of TRIMs. We would add that this figure identifies measures that are also inconsistent with Article 3, 4 and She, 1 of GATT 1947. Indeed, the TRIMs agreement is not intended to impose new obligations, but to clarify the pre-existing GATT 1947 obligations. Under the WTO TRIMs agreement, countries are required to rectify any measures inconsistent with the agreement, within a set period of time, with a few exceptions.